Give any to machine gun?
Yes. Right, it might be the one.
Leah, I'm gonna ask you to kick us off, I don't know what's.
No, let them.
Don't know where, thank you, let's see that.
So this is an updated version of the contract. It's not tracked change because then it would look super scary. Because it's substantially different in the sense that I've changed the formatting. I've changed a lot of the overly complex language. But I provided an executive summary of changes that highlight the area where pretty much that every article was changed. If you can see, like, even from the front, how it looks a lot different, because I added your guys' logo, our logo, and everything to it. But the primary areas where there were changes, if it's explained a little bit more. And I think we'll kind of talk more about it, but most importantly, Article 8, Article 11, Article 19, I'm sorry, 17, 18, 19 are the changed areas. 17, 18, and 19 were formerly 20, 22, and 23. So I even rearranged some of the articles. So the more like, the term of the agreement, severability, I moved all that stuff into the end instead of it being kind of in the middle. And I noted that it's, those were the former numbers. And then I'm sure the rest of the people will be able to speak to the different areas in the agreement where the substantial changes were. And for the most part, the plan was to simplify the language, make sure that terms like employer, employee were used, consistently, changing FOP to union, and employer to city throughout. And, for example, one of the other changes, it looks like a substantive change, but it's not. When we're talking about the calculation of overtime, changing the language from it being calculated for time worked, a quarter an hour or less is rounded to a quarter hour, and a quarter hour to half hour is rounded to half hour. I just changed it to, for the purposes of calculating an hour, any time work less than 15 minutes will be rounded to 15 minutes, and any time worked between 15 to 30 minutes will be rounded to 30 minutes. And that's how, like, the time will be calculated. I didn't actually change any of that. The language itself changed. So you'll see that throughout, that there's language that's changed, but if you compare it, it still means the same thing.
Okay.
If it doesn't, then definitely let us know, but it was the plan.
Yeah.
For that.
Assuming this, overtime, this has to do with the new laws that were put in place for overtime.
Yes and no. So, I don't know if we're there talking about that, but that is part of the justification for some of the changes.
Okay. As far as the tax way overtime is tax.
It's more of the federal exemption that employees are entitled to.
Okay.
For that,
Got it.
yes. The tax isn't changing, it's how you receive a benefit from the way that it's counted.
Right. Okay. Yeah. Yes.
It's 11.
All right. So.
Well, I don't know if everyone wants to present the changes.
So it's Yeah, just mark it.
I guess I can start walking through some of the numbers. The standards are not big changes. And I would start at Article 6. So articles, the preamble and articles 1 through 5, that there are changes in there, but it aligns mostly to simplify the language, but also to make it consistent with the purpose and authority, recognition, management rights, strikes and lockouts, to align with how we treat our fire union for the most part. So in the past year, strikes and lockouts were very minimal, and I expanded it to how we treat our fire union as far as strikes, lockout, picket lines, strikes and businesses, stoppages, and recognition of strikes or stoppages and violations. So that's just, it's expanded, but it aligns with how we have treated our other union. That language just wasn't included in the contract. I intended here. Article 5 is the same, it's simplified. But Article 6, union security, the payroll deduction is where a majority of the changes were. And so now an employee is required to submit the payroll deduction form to the city instead of the union submitting it to the city. That's what the prior language was. And so an employee has to submit their payroll to the city and the union instead of it coming directly from the union. Not necessarily, I don't know if that's necessarily how that practice actually was, but it's consistent with how finance typically receives those forms and processes them.
I'm sorry, what forms are those?
The deductions
Deduction,
for your
okay.
dues.
Yeah. Okay.
So the city will still be providing the deduction based on the form submitted by the employee. As usual, it's just instead of the form coming from the union, it's coming from the employee.
Okay.
So if they fill it out and bring it to the city instead of like someone from the union filling it out and delivering them to the city.
And that's for new employees only, or is that all of us? Okay.
Well, it's for all, so if you choose to get out of the union, you would submit your
Then you
form
do it
to
in person.
stop it. The way it was before, it was still the union providing it to the city, and that's not typically consistent with how that stuff is done.
Okay.
Because our relationship is with the employee and your relationship is with the employee as well.
Okay. I understand.
And then Article 7, clothing allowance, there are some material changes. And I don't know, I guess I can keep walking them through.
Yeah, I'll just jump in, I guess.
So in section 1, the non-duty uniform allowance is being it's still $50 per month to be paid the second paycheck in October for in advance for the next 12 months. And it's still the same employees. It's section 2, the shoe and boot allowance is changed to boot allowance. And that allowance is being changed where the city will reimburse uniform personnel, evidence custodians, and animal control officers up to $200 per fiscal year for the purchase of a single pair of department approved boots, provided they provide receipt to the city's finance department. Previously, uniform personnel, evidence custodian, animal control officer, computer system specialist, and record specialist receive an annual shoe allowance of $150 paid in the second paycheck of October and paid in advance for the next 12 months. So that's where there's a material difference. So the types of employees that will be provided the shoe boot allowance is changing. The amount is increasing, but it's on a reimbursement basis. Section 3, glove allowance is also being changed. I believe, no, 3 wasn't changed. Section 4 is changed a little bit, the dollar value, aren't being changed. But the language is being changed that, sworn personnel, they can have any item of clothing that's damaged, seized for evidence or stolen while on duty. Before it didn't say, or actually it did, but it's consistent throughout this on duty. It'll still be done at the city's expense upon approval of the chief of police. But if they have items, that are contaminated by body fluids during the performance of their official duties, they can get approval from their supervisor instead of, I guess that's the same too. Sorry, like I said, I changed a lot of the language to make it clear. And then making it clear, for the last item, for this list of items, the city will repair or replace at the city's expense upon approval of the chief of police, or their designee within a reasonable time frame. The following items, but that those are maximum amounts for the items listed. That's the section 7 changes. Article 8. The work period is remaining the same. It's just defined now as a week. So references to a week mean Saturday at 12:01 AM to Friday at midnight. Overtime will be paid for hours actually worked in excess of 40 hours. That is also a material change. And that is a combination of aligning with the city council's direction that all employees, including our unions, be at will. Compensated for hours actually worked for overtime purposes. It also makes it better and easier for the employees and the city to track the overtime. So that's where the federal overtime changes come into play. Based on the FLSA rules, employees will only be able to deduct actual hours worked overtime, for the tax years of 26, 27, and 28. And if we continue to pay overtime for hours not actually worked, we'll have to figure out a different way to track that, because the city has an obligation to report those actual hours of overtime to the federal government on your tax forms, your W-2. Where if you're receiving overtime payment for hours not actually worked, you're not entitled to the same deduction.
So in the event that this law does not remain after 2028, does that language then become available to be changed after that back to what it was before?
That will be the next negotiating term, so I don't think anyone here can say for sure whether or not that will be something that can be negotiated into the contract. The section's also been rearranged too, so, there is a section that talks first about overtime, and then it'll talk about compensatory time. And in the compensatory time section, the amount of the compensatory time to accumulate is still the same, and the amount that you can redeem is still the same, except it's being changed from payout twice per year to a quarterly payout. And if your accrued compensatory time exceeds 120 hours at a quarterly payout, which is in the next paragraph, then they'll automatically pay out the amount over the 120-hour threshold.
So we can accrue to 240, but we can't carry on.
Past the quarterly period. I'll speak to that.
Well, yeah, this is one of our requested changes because the issue we have right now is you have a lot of officers that are at that max. And they're not managing it, so every payroll, everyone's having to do additional processes to determine who's exceeding the 240 and then convert it to overtime. So every payroll, she's finding somebody and having to make those conversions. And so this is similar to what we do for another labor group where we cash them down and then you have, you know, the next 3 months. The likelihood next 3 months you're gonna be at that 240 max is not towards the end of that quarter. So it takes a burden off of payroll.
It also affords employees the opportunity to request additional payouts in the event of an emergency. With approval of the chief of police. So if for whatever reason, you need an additional cash out of your compensatory time, you could submit a request to the chief of police and receive a payout. And so section 4 is what used to be section 3B. It's now called planned events. And that should still be the same. There's a new section 5, which is a combination of a couple of different sections here, and it's called court appearances. And it covers court time, court preparation and appearances, court cancellations, and late scheduling of court time. And so it's combining all the different mentions of court times in this article. The major changes here is related to court preparation and cancellation. And changing it from verifying your attendance 1 working day before the court appearance. It asks that you verify the appearance is necessary 1 day before the court appearance, so roughly 24 hours. And then if you get canceled in less than 24 hours, you still receive your 24 hours of compensatory time. And if you're scheduled less than 24 hours, with less than 24 hours notice of court time, you will receive a minimum of 4 hours paid at 1.5 times your regular rate to prepare for your court. In addition to the other court time compensation that you receive. That section 5 is the same. In section 9, we've added Juneteenth as a holiday. And that's consistent with the rest of our holiday policies. Article 10 should substantially be the same. Article 11 is related to wages. We took out that section 1 because there's not a new salary schedule yet. That hasn't been negotiated. Section 2, providing for salary adjustments. That has been changed to provide for a salary adjustment at the discretion of the city council to be increased by a maximum of 2.5%. And that leaves it to the city council when they set their budget about setting our salary adjustments that they typically do. They typically frame it as a COLA adjustment, but there's nothing express in our personnel policy of what it's called. It's not expressly called out as a COLA here, so we're keeping that same language consistent throughout, but that's typically what it's referred to as. And then section 3, the incentive pays, that's a combination of consolidating all the different types of incentive pays into one section. I know you recognize that in your request, the city, that was part of one of our plans too, was to consolidate all of those. But we haven't made any changes to that as far as the amounts at this time. So everything that is in the current contract is still in
That's what
this,
you put in there.
because I knew that we were gonna be, that's one of the areas that we're negotiating. So all of the amounts are the same as they exist as they were. So even like the SWAT PT scores, it's still in here for right now.
Yep.
The only thing that was kept separate was the education incentive pay, because that's not based on an assignment. Article 12 is still substantially the same. Article 13, though, there are material changes to that based on the chief's plan and prior discussions between the union and Nikki. As far as promotional testing, filling vacancies.
Chief, this is your language, isn't it?
Yeah, double checking. I don't know.
For the most part.
Yeah, so I think, so the bones of it are still kind of the same for promotional, but just the language I wanted to have is just a little more flexible. If I wanted to go exclusively with like an outside assessment center, it was a little vague in the last contract, so I just added some language about being able to go in that capacity, but it'll still, whether it's internal, external, or some combination thereof, just at my discretion when we set up a testing process. Added as one of the potential standardized test bars, a peer review that we talked about, so kind of do that in there in the mix for helping test.
What section did you put that into?
Once,
Most of those you're gonna see in those
Yeah.
numbered sections, 1 through 9.
but then still, when it's all tested done, we'll still, you said the HR final grading, that's all staying there. And, not as, being on type on the top 3 is still there. Like I said, it's really more the flexibility, but I did add, the caveat towards back to section 2 and 3, promotional eligibility. The level 3, that's when I talk about, trying to work on a discipline matrix, they'll probably get changed to where I may just put in where the prior language like, if you receive a record of, sustained finding of, where, the ultimately it's a record, not discussion, but probably record of a discipline or higher one, yeah, or higher, that would make you eligible for 12 months from the date of receiving this. And then that just kind of goes in with the disciplinary suspension. If anybody's been suspended, which is obviously a pretty high level, conduct or high, they would just not be eligible for the testing for 12 months. Oh, and then, yeah, to the caveat about the So, because we just had that situation, if you decline a promotion, when you knew that, you basically go to the bottom of the list. I don't think they have like, oh, you know, I like to pass, you'll, that can't even go to the bottom of the list. If they are the only candidate in the meeting or the only candidate, then I'm proposing to then just list and scratch me with the test.
That's number 9 on the list.
Yeah, there we go. That way, they're not necessarily, even if they decline the four people, what's that when they're not just done, they just go to the bottom of the list. Doesn't remove them from the list.
Okay.
Those are the 5 kind of big changes. Okay, the way that. And again, even if they decline, it doesn't ever prevent them from future promotion opportunities either.
Article 14 is still the same, it's just changed the title from personnel reduction layoff notice to reduction in force. I also simplified it because sections 1 and 2 provide for the same period of notice regardless of the time. So one says if you have less than 3 years, you get 30 days calendar notice. And one says if you have more than 3 years, you get 30 calendar days notice. Just been changed up, all employees get 30 calendar days notice. Because it's the same regardless. But the rest of it is just the same. FOP activities, the change to union activities. It did add that you wouldn't do any fundraising or political activities while on duty. On duty injury, I added illness because that's obviously the intent of the policy is to include injuries and illness. Whereas before it only stated injuries. So if you had an on-duty illness, this contract didn't recognize that in this article, so it's been expanded for that. But otherwise, it's generally the same. I changed some of the language to be consistent with the intent here. But otherwise, I didn't make any changes to it. The current Article 17 in the existing contracts then moves to the end of the agreement. As well as the 17, 18, and 19 have all been moved to the end. So the next section, the new Article 17 is shift rotation. That's another one where there's substantial changes based on my understanding of what police chief and human resources have been working on with the union.
Yeah, and that's just going to 6-month rotations, and then having basically the bid about 30 days instead of 60 days. That'll be the same with patrol and communications. And then it worked in, where communications though, any dispatcher coming off. Propane will still be placed by the manager, commander, who's, overseeing the unit. For their operation, but in patrol, it'll go to the bid process. Once they have communication, they will be able to bid at the next shift bid. Have to be replaced obviously at some point, but when they're completely, but once the next shift cycle comes up, they'll bid by rotation and not just have it placed until they're on probation. And then also, having the bid begin at the beginning of a pay period. They also want to follow where kind of the mid-pay period. But if it goes beyond kind of the rotation period by a week or so, begin at a pay period, just kind of a cleanup break. Yeah, but the problems that kind of fall back to the original language, the old concept, the way they're doing the bidding itself.
That is a 4 months.
Yeah, exactly.
So the new, Article 21 was moved to the very end of the existing contract, the entire agreement, so that's the very last article now. Article 22, disciplinary action, that one has substantial changes to it, it is now Article 18. And it's titled investigation instead of disciplinary action. Because, it appeared that the intent of Article 22 was to cover all types of investigations, not just those investigations that led to disciplinary actions. So we made that change, but then also changed what the process is. So, I know my experience and Chief Cusick's experience as far as on the city side of initiating or managing these investigations. There are different policies depending on who initiates the investigation. And that is what the new language provides, that a personnel or internal affairs investigation will be conducted pursuant to either the personnel policy initiated by the city or the department policies if it's an investigation or IA initiated by the department. And cases involving misconduct involving harassment, discrimination, or retaliation can involve the human resources director and the city attorney, and the disciplinary proceedings arising from them. But one of the big things too is that it's not forcing notice from the city to the union. It's requiring that employees notify the union of any types of these investigations. Partially because it helps protect employees and their privacy. Employment actions are not a public record. And so as a duty from the city, we are not obligated under state law to share personnel related disciplinary action to third parties without the written consent of the employee. You know, whether or not they're consenting to that by being a member of the union, it's not entirely clear. So, you know, we like the position of, we will provide the employee notice. It's the employee's obligation to notify the union of this and to involve the union. And not making so that if we initiate an investigation on an employee, that we're required to notice the entire union board, who may or may not have been someone making a complaint against another employee. They might be the subject of the investigation, or it might be a sensitive type of investigation, and they might not want to actually involve the union. So it's kind of giving the employee the choice on whether or not the union gets noticed. Also in section 2, it does provide that all employees of the department are at will. This is also a material change. Instead of being that they can only be terminated for cause. But it does state that the city has the right to discipline employees for cause. So that is also a significant change where currently you can only be terminated for just cause versus being an at-will employee. That's another one of those directives from the city council. They want all employees to be at will, regardless of affiliation with the union. And that's based on this state of Idaho being an at-will state. And then the rest of the employment groups being at will, except for one other union group.
There's another union groups to fire.
Say that again?
Is that the other union group to fire?
Yes. And that is the only union that we're required by Idaho code to bargain with.
Right.
So, for the most part, section 1 of the existing contract and most of section 2, but not all of it, have been consolidated to reflect a process that's either the city's workforce investigations or the department's policies related to IAs and other types of investigations. Section 3 is still in here. There are some changes related to that in the sense that When an office or when an employee is involved, whether on or off duty in a use of deadly force or other critical incident, or use of force. I'm sorry, use of deadly force. Or they discharge their firearm with no injury, they will not be required to make a written or recorded statement for at least 72 hours after the incident, except in, for certain reasons. And they will be placed on paid administrative leave, that will not be accounted against them. It doesn't limit it to 3 days anymore. It's for whatever amount was determined, by the city. So it may be more than that. But it's not likely to be less than that because you do have that 72 hour, minimum time before you make any kind of statement. It's not expressly clear, but it's open ended. So that is there. The rest of it, related to the consequences of refusal to submit a polygraph is still the same. Article now 20, or sorry, Article 19, which was previously 23, grievance procedure, that is also substantially different. A lot of the changes were to simplify some of the actions because they were kind of redundant. But as far as the material changes, there is now the inclusion of a process that if an employee who's a member of the union must first deliver a grievance to the union, and the union has to determine whether or not they will pursue the grievance on behalf of the employees. That's not previously in there. And so it allows the union to provide an opportunity to consent to or not to represent an individual in their grievance process. And in the event that the union chooses not to represent it, then their grievance is terminated. The employee can elect to proceed on their own at their own expense with the grievance. But at that point, they will not have the union's backing because the union has made the decision they will not pursue the union or the grievance on behalf of the employee. It also makes it clear that the union is not obligated to provide any kind of representation if they choose not to. So that is now the step one process. The employee must submit their grievance to their union, and the union will follow a process to determine whether or not they will approve or disapprove of the grievance. After the union has reviewed that and they determine that, and then they will make written findings that they will present to the chief of police if they decide to pursue the grievance further. The timelines here, for the most part, are the same. It's 15 business days. Again, a business day is Monday through Friday, 8 a.m. to 5 p.m., not including weekends or holidays for the purposes of this entire article. So anything that happens outside of those hours or on a non-business day, a day that you start calculating begins the next business day. So if something happens on Friday at 4:58, that counts as day zero because that's a business day. If it happens on Friday at 7 p.m., then the next business day begins on Monday, and that becomes your new day zero. And likewise, if the last day is, you don't count the weekends or holidays as a part of calculating time for anything. Step two, after approval by the union or the main body of the union, so if the union body or if the union executive committee decides not to pursue it, the member can appeal to the union body and kind of force the union acting that way. That's still all in step one. So after all that's been worked out, step two, they present their written findings to the chief of police no later than 15 days after receipt of the grievance. And then the chief of police makes an investigation and a determination on the allegations in the grievance. And that they have, 15 days to initiate an investigation and to issue his written findings. After that point, if the grievance isn't satisfied, they can appeal up to the mayor. And they have 10 calendar days from the receipt of the chief of police response, or if no response is received within 10 calendar days from the date the response was due, the matter, can be submitted to the mayor, and the mayor will do an investigation of the grievance. And he has 15 business days from the initiation of that to hold a meeting with the grievant and his representative to explain the results of their investigation. And the mayor may elect to have human resources, chief of police, or city attorney, or any combination there present for such a meeting. And the mayor's response shall be the final decision on the matter unless mediation is pursued. And then it provides a process for mediation. The grievance by the city language is the same as what's in the current process. I might have changed the timeline to be more consistent with the rest of it. And then mediation, for that one, either party can initiate mediation. Has to be, you have to provide the notice to proceed with mediation within 10 calendar days of receipt of the mayor's decision. And then for mediation, you will select a mutually acceptable mediator from a list of qualified mediators from the clerk of the Idaho Supreme Court. You'll alternatively strike a name from the list until the parties agree on a name, or there is only one name remaining. They'll be the mediator, and they'll mediate the matter. There's not a specific process defined. But if the parties are then still unable to resolve the matter, the method of pending resolution shall be litigation in a court of competent jurisdiction. Mediator will meet the parties to endeavor to mediate a mutually agreeable settlement. The settlement agreement will be signed by the parties and will be binding. And any information provided or comments made during mediation cannot be used during litigation. That's standard in the legal world. Typically, matters of mediation or evidence and statements made in mediation or cannot be introduced as evidence or used for any court proceeding. And then a settlement agreement between the parties, any settlement agreement between the parties will also address fees and expenses related to mediation. The non-prevailing party will pay the mediator's fee. If a prevailing party cannot be clearly identified, the mediator will determine the party who must pay the fees or may require each party to pay 1/2 the fees if the decision is split. And if, or the parties may mutually agree to any other arrangement related to the payment of costs and fees related to mediation. Remedies related to discipline is the same. A failure to appeal is kind of it's the second paragraph of subsection F under time limits. It simplifies the language. But it does take out the part where in the event the department fails to answer a grievance within the time required at any step, then the grievance is settled against the side which defaulted. If the new process provides that if you fail to receive a response, you can move on to the next step. It doesn't terminate the grievance at that point. It also provides, as far as the time limits, either party may request per step to have an additional 10 business days for their particular side. So previously it was 10 business days by either side. When the request is made within 15 business day window, one request may be made per step. It wasn't clear that it was one request per party. So if the grievant needed an additional 10 days and then the city needed an additional 10 days, you could conceive a potential 20 business day extension if, based on the needs of the party requesting it. But it's up to 10 business days, so you don't have to do the full 10 business days. And then section 3 is the same for the most part of section 4. It's been rearranged a little bit and simplified, but a majority of those terms are still there. There was, I can't remember which one, but some of them were moved elsewhere in the paragraphs. And then the meetings, it said before scheduled during normal working hours, that was changed to department business days. So again, that section is one that was substantially changed. And so then pretty much a new process is being. Article 24, alcohol and substance abuse. It says the parties have agreed upon an alcohol and controlled substance abuse policy. This, my understanding is that's the city's policy that they've agreed to. So here it says agreed upon the application of the city's drug-free workplace policy. In reference to the different areas, that is what's currently in the contract. That section has been added to that as well. So it keeps all the same modifications there. So Article 25, vacation, is now Article 21, vacation leave. A majority of the language that's currently in the contract mirrors city's vacation leave policy. And so, it states that it follows the city's vacation leave policy as amended from time to time, except as modified herein. So this is where the areas that were different were kept in here. Article 26, sick leave, is now Article 22, sick leave. Again, the parts that were the same as the city's, for the most part, it's the same as the city's leave policy. So that's been reflected in here. One thing that is different from the city's leave policy that is currently in the contract that's still in here is that the employee is absent for 3 or more days. The chief of police or their designee may require a written statement. That's all existing in your contract. Again, I didn't make the changes to the accrual rate. I know that that's an area that the union has requested a change, but for now, I've just kept it the same. Article 27 has been moved to the end. Article 23, personnel files. That one's been changed a little bit in the sense that there's a section for official personnel files and there's a section for department personnel files. But section 1 says that only one file will be kept. So I've changed it to say that only one official file will be kept and that the department can keep a personnel file of their own related to internal affairs investigation or supervisor's file. Because my understanding is that there are department kept IA files and department kept supervisor files that are not a part of the official record for the employee. And so that recognizes that. Whereas before it just says only one file may be maintained, period. Department personnel files are still not open to the general public or other employees. An employee or their authorized representative with the employee's written consent may review department personnel files about the employee in the presence of an appropriate supervisor. That's what's currently in your language. It was just, it just previously said the general public shall not have access to department personnel files or supervisor files. So it also made that other employees are not allowed access to your department personnel files unless they have your written permission. The duration negotiation for renewal, that's a new Article 24. That's a combination. That's what Article 27 was, and also kind of the effective date. But this provides a process where it's unclear exactly what the process is for negotiations for renewal. So the effective date of this agreement is October 1, 2026 through September 30, 2029. It states that the union will provide notice of your intent to negotiate a new collective bargaining agreement no later than February 1st. That Request was then be presented to the Lewiston City Council within 30 calendar days to receive approval, and upon approval by the city council to negotiate a new agreement, the parties will schedule an initial session at which the convenient time and commence negotiations. If a new agreement is not reached upon expiration of the agreement will remain in effect and unchanged until a new agreement is. Article 25 is the non-discrimination clause. Article 26 is severability, and Article 27 is the entire agreement statement. I did not make any changes to this wage matrix here. That is what was currently, it's more of a placeholder for the time being.
Is the current one.
Yeah, that's what's currently on the contract.
But it's not the current one. The contract one is the first year of that contract.
So it's just a placeholder right now. So that's a substantial increase. But you'll notice that the language, there are other changes, but the intent was not to change that as far as how it's applied or what the intent is, just to make it simplified and
Language for
less
that.
wordy.
Man, initial question.
Give it to them. Give it to them.
So with, so if we work out the mom. And then we have an overtime shift, we can give any overtime.
Yes.
Doesn't now.
Absolutely.
Do we have anything else from the city as far as?
What you guys decide on this? I don't know, do you guys wanna hear this now?
We haven't talked about any of that yet.
No, okay.
Nope, that's it.
Not yet.
So I did, give you guys other paper to address that. Notice it was the. Agreement negotiations from us. Last meeting, there were a couple things that were added. I apologize. The first one was the clothing allowance. I thought I included that. That was an update to, prices that are reflected in Article 7, which of course have changed up. Those are updated prices, on those. Or updated amounts, rather. What things cost. Let's see some of them. It's like contact lenses, it's 232, it's supposed to, that's like grammatical error there, or an error. MC means no change. Is what that means. The contact lens is the only one that price comes over to the new, it's just contact lenses is gonna be no change. It would be the request. And then the other ones on the next page for section 5, requesting the increased investigation section personnel 10%, versus 5%. All other specialty assignments would stay at 5%. The reason being for that is a couple reasons. For one of the big ones is our investigation team is required to be on call. They don't receive any compensation for that. That's one of the big ones, and that's actually also reflected in argument for that. It's also reflected in the city policy on the next page that I copied on there, so highlighted in yellow. They're also required to maintain a higher level of training as far as or pertaining to the investigative crimes that they investigate. Currently, there is nothing in place for call out. Right now, we have a minimal amount of detectives that are usually the ones that are coming out to call outs. Is there anything you want to speak to on that, James, since it's your unit? And also the 5% that they receive once they go to the investigation unit, they give up their all-day pay. That 5% does not cover the amount of money that they've lost compared to the holiday pay. Does that make sense? Explain that.
The 5% on what they accrue over the year is less than they would get if they were on patrol, receiving call.
Basically. Thank you. And then the final is I just fixed that error. It said communication officer or whatever I had before, and I just fixed it where it should be as code enforcement when pertaining to Doug Willie. And then the other piece that I handed out was, as far as the language proposed. Records department, currently there's nothing in place for emergency evacuation, loss of workstations. It's a proposal to protect them. Yeah.
So, I mean, I
Good.
can
Yeah,
tell you
I
why
thought that
it
would be-
changed if that
yeah.
helped. So we used to go to 16th Avenue if there was a catastrophic failure for dispatch. Now Nez Perce County has become our backup center. They do not have enough consoles or enough workspace for records to move there. So this is protecting records in the event of a catastrophic evacuation or a long-term evacuation where they cannot work at the department for any reason.
The sheriff's office, not.
Yes, the sheriff's
I was
office.
like, the courthouse
Yes.
wouldn't make any sense.
No, the sheriff's office. So they gave us a console over there, so we would at least be able to operate. There's no room for two record sections, or two records individuals to work in there as well, in addition to us.
Where's that at? I don't.
Did you know you wanted to?
Which one? What's it?
So with the bold print on top.
Okay. I'll look back here, thank you.
Non-exempt employees, right?
Yes, yeah. So is this basically just saying they would be excused from work and paid for?
Yes.
Okay. So I'll make sure I'm reading it.
Yes, that's the gist of it, is that they won't be punished for us not having a place for them to go, that they will be paid wages, even if there's not a place for them to go.
And there would just be no expectation that they would work. Won't work.
They're what?
There's just no expectation that they would work.
Yes, because there's nowhere for them to.
Well, they wouldn't, yeah.
They didn't have abilities.
Yes.
Would they be required to be accessible during working hours?
Yes, I would assume so. Not a free paid vacation, just because there's no place for them to work.
Yeah, so you say it.
I know, this language came from, the records supervisor, and so.
Something like that project.
I try to stick to the original effect. Not comfortable. I did want to note your Article 11 on here, for the most part. I did that, those jobs were relocated all under the same, subsection.
Right.
So I just wanted to make sure that that was noted. I didn't make any changes to like the actual amount that were currently being adjusted. But the motorcycle duty, the brush test specialist, and there was another, and canine officers are all under
Clean that
the
up. Yeah.
same FOP assignment section now.
And like I said, this was just, I brought what I presented last week. What we presented last week was just.
Yeah, that was one of those easy changes that we were thinking along the same line.
Yes.
And I'm just not sure if your, shift rotation, that's exactly what you guys were, discussing before, but my impression is that it's generally what everyone had intended it to be, but just.
As far as,
This, Article 20,
um,
it's different number now, but related to shift rotation, bid eligibility for probationary.
oh,
It says
yeah,
modify the language to allow probationary employees to participate in shift bidding at first available opportunity following completion. So the way that it's worded in the current, and what I propose is that it says that they'll be assigned, like upon completion of their FTO, they'll be assigned to shift, but then they'll then be able to participate in the next available shift bid. So
yes,
it's, I think it's the same intent, it's just a little bit different language,
gotcha.
so.
Yeah.
Just make sure you read it and that you understand that that's what
That's what you were
that's what it
intending.
means.
Yeah.
To you.
Also another thing, this is, I didn't print off my copies because it's quite a bit, but this, was at your request for, my liability endorsement dollars.
Yeah. So with that, currently, all your FTOs receive a 2.5%. So your request is to reduce that low liability to 1.5%.
Sorry, okay, so.
Just to understand, you saying FTO is low liability?
No, I'm just, you guys are making the distinction between high and low liability FTOs, but under the current language for that. I believe all FTOs, while they have a trainee, let me look at it.
Usually 2.5%, while they're,
An instructor is different from an FTO, though. You can be
Yeah.
an instructor and not be an FTO.
So field training officers, field training sergeant, or communication training officers shall receive an additional 2.5% of the employee's base wage while assigned to trainee. That's the only additional incentive pay that's in this contract. There's
Right.
nothing else related to any other training officers.
right, and that's what would be one of our additions that we were requesting. As far as high and low liability. Which we discussed last week,
That an additional incentive.
Not currently. Yeah,
The original proposal rate.
Okay,
Instructor pay versus training.
yeah, FTO, that clause would, we request that remain the same because
Okay.
it's separate from instructors.
yeah, we're going to.
Yes.
so then that would be a potential addition to those aspects. Okay, I just wanted to make sure.
And then, later there's the IDAPA. That got, for what a high liability instructor is, and mostly it's in, I think page 1 and 2 are, it labels them out.
Now, this instructor training that you received, is that something that you have to pay for yourself or that's paid by the city?
Typically it's paid by the city. Any questions on that? Either side? You guys don't have anything?
Okay. That's like it.
Yeah, you have it separate for.